Joining us now to discuss the probe is Judges Matters Alison Tilley. Good afternoon, or rather good evening, Alison. Thank you very much for joining us on the program. Let's start with the significance of this matter, given the glaring power dynamics. You have a complainant who was a junior staffer and the accused a judge precedent.
I think that that's probably one of the most extraordinary things about it, that it is a judge who has been accused of sexual harassment. And I mean, one of the things that we know as judges have to act honorably. And I think, obviously we will await the outcome of the tribunal, but certainly the evidence so far is really damning. And I think certainly from the discussion about it on social media and other platforms, people are saying, well, yes, but didn't she acquiesce? Didn't she consent?
Yeah.
And I think precisely pointing to what you just said, the power relationship between the two, and how what she was doing in the situation was, dealing with a much older, more powerful man who's also a judge. And I think we have to read what she did in that context.
Mm-hmm. Now, on the case itself, at issue is whether what transpired was consensual, as you state, as the judge precedent has claimed, saying at best it was flirtatious and possibly playful. Let's say it were found to have been flirtatious and playful conduct. Is that conduct, though, appropriate for a judge precedent, especially with a junior?
No, it's absolutely not. And I think the judicial code of conduct speaks to whether or not it's appropriate, and if the allegations are proved, and we don't want to get ahead of that. But there's no question in my mind that the conduct would rise to the level of impeachable conduct, and then then the question has to be dealt with. Is it something that needs impeachment, or is another sanction appropriate?
Mm-hmm.
But I think if there's anything that we can take away from this that's a good thing, is that I think it's got people talking and thinking about what sexual harassment really looks like in the workplace.
Now, Alison, the submissions by the complainant have again been the subject of debate, where it's being said some of the responses, as you stated as well, to the judge precedent also left them confused, suggesting it must have been consensual. She's maintained, though, that she had no choice but to respond in the manner she did, given the power dynamics. But not to have you responding to the merits of the case, but just share your views on the exchanges expected in such an inquiry, because some hold the view that the line of questioning could lead to secondary trauma, while others say no. There must be a poking of holes into her testimony, because here what is at stake is that a judge could be impeached. So every single statement she makes must be scrutinized. And we've got Advocate Moses Kakane, who is representing, of course, the judge president, so that we must expect that level of exchange.
Look, I think there's no doubt that this process will cause secondary trauma. And it might well cause what's called vicarious trauma as well. So, the people who are in the hearing are hearing distressing exchanges, and they need to take care of themselves because of that. I think one of the things that maybe I hope we learn from this is that when you have a junior person in an organization, and they're a woman, and they're subject to all those gender norms about being polite and being nice and being kind, that's one thing. You then have a lack of reporting mechanisms. You have often in the legal profession and in the judiciary as well, the magistracy, there is sexual harassment. We know that. And we know that it's what, in particular, magistrates and judges have said to us, is that it is career ending to report it. And there's a real fear of retaliation. So I think when you look at all of those things stacking up, and a very junior employee whose livelihood is at stake, I think you have to understand that what may look like somebody smiling and nodding and saying, yes, but that's enough now, or no, thank you, or not today, maybe that doesn't feel like rejection, maybe that doesn't feel strong enough, but I think in a workplace where those relationships are so unequal, it's to me, that I think is something that we have to understand as sexual harassment.
Alison, you know, when you speak of the sexual harassment and say that, having spoken to people within the legal profession, that most of them saying to reporters career ending is honestly quite disheartening. But what exactly needs to happen if, as you suggest, this is actually an open secret, that there is some sort of sexual harassment that takes place? And of course, the judiciary enjoys great respect in society, and for this to be happening there, these are people who are custodians of the law themselves. So it's quite disheartening, but what needs to happen here?
Well, I think there are a range of things, and I think that, as I say, one of the things we can take away from this, which maybe will encourage you a little, is that we are having this discussion, and we are talking about why, it may be that for a day or 2 days or a couple of months, it may seem like somebody's playing along. But that literally is what they're doing. They're playing along, and they're trying to make sure that they keep their job and they can pay their school fee, their kids' school fees, and that they can get out of the situation without offending the person who's senior to them to the extent that they then want to dismiss them. So I think that's one thing. I think we've got a policy on sexual harassment which the Chief Justice has been responsible for developing. And I think we're going to look more closely at reporting mechanisms. But this is a tough nut to crack.
It most certainly is, because if you're even saying that element of playing along makes it quite difficult for an arbitrator, that in this instance, you are somehow meant to comb through all of this and understand that I've got messages that might send mixed messages or indicate that perhaps this was consensual, but I was merely playing along. But if you are a person that is accused, burden of proof is upon you. So you've got Judge Mbenenge here, who must decipher and somehow put into play those power dynamics you mentioned, but really at the heart of it, if you're dealing with hard facts, if one has played along, it's not something that is evident when you just see a suggestive SMS.
One suggestive SMS, yes. A pattern of behavior over a year which results in somebody having, to leave their workplace and go and work somewhere else, that results in this level of trauma. I think that's what we're going to have to be looking at in these kinds of cases. And I think we have to believe survivors. If a survivor and to use the sexual offences context, if somebody says it was rape, we believe them. And that's certainly the position that I would take. You don't need sworn affidavits from people who say that they saw something. That's not how it works. There's not going to be that kind of evidence. You have to listen to your complainant and see what the pattern of behavior is over a long period of time, and long maybe be weeks or months, or in this case even longer, and then look at what the excuses are. And I think particularly for somebody at the level of a judge who is supposed to act honorably, the idea of hitting on a secretary and then sending her pictures, there is no context in which that's appropriate. It doesn't matter, how the judge felt about it or thought about it. As was pointed out, he's a married man, he's a pastor of a church, he's a judge. This is behavior that I would say is unrecognizable as appropriate judicial conduct.
Alison, thank you very much for your time. It most certainly will be quite interesting to see how that tribunal looks at this matter and the conclusion that they arrive at. But thank you very much for joining us this evening. That is Judges Matters Coordinator Alison Tilley speaking to us.